Well, I've tried to compare 12406 with the Insurrection Act language because it seems that the Insurrection Act is conceded to provide an exception to the Posse Comitatus Act. And interestingly, the Insurrection Act seems to make it much more clear that it authorizes both a calling forth into federal service and then use of the armed forces. It literally says, and use such of the armed forces, and that turn of phrase does not seem to me to exist in 12406. And then there is some tension with, I think, the parties' views about what constitutes execution of the laws, whereas the federal defendants are arguing merely providing a protective detail is not execution. So I think one way that could be reconciled with the difference in language between 12406 and the Insurrection Act is to say the 12406 might authorize the calling forth, but to not execute the laws, but merely to enable civilian law enforcement to execute the laws, and the troops would not be directly engaged, essentially in the way prohibited by the PCA. But that's in my mind, is one way to reconcile textual differences between these different statutes and what I understand to be historically how we've interpreted in our precedent what the scope of the PCA is. Do you have any objections to that view?
We don't have any objections to that view, and it's certainly a reasonable way to reconcile the different statutory requirements here. And it would go part of the way towards explaining a little bit of the historical oddity of Section 12406 and its redundancy to some degree with aspects of the Insurrection Act. There is this kind of strange question lurking about what Section 12406 is doing, and partly that question is lurking because it's been so seldom used. It's only been used once in the history of our country since it was first enacted 122 years ago, and there's generally been an expectation that if the president has if the circumstances are extraordinary enough to justify calling out the military for a domestic deployment, that would rise or fall under the Insurrection Act. So I think that is a plausible way to reconcile the competing statutes here. The other thing I'd say...
No, he's trying to say, well, the president's going to call for the military for domestic purposes, that he should really use the Insurrection Act. First of all, no. 12406 provides independent authority to federalize the National Guard for domestic use. Second of all, are you sure you want Trump to use the Insurrection Act? Because the Insurrection Act lacks all of the conditional statements of 12406.3. It essentially allows Trump to do anything he wants with National Guard troops federalized under the Insurrection Act. Is that really what you want? I mean, it's what I want. I would love to see that. But is it really what you want? And by the way, I don't claim any great expertise on Posse Comitatus law, but I would just note that what Posse Comitatus literally means is the power of the county. That's what the words translate into. Posse, we all know Posse from the Western Unions, right? The bank gets robbed in town, and the sheriff pulls together a group of the townspeople to ride with him to chase those bank robbers. The townspeople are not normally law enforcement officers. They form a posse. They form a posse to enforce the laws. But I would suggest here they're specifically enforcing the local laws, the state laws, the county laws, not federal law. So I think an argument could be made that like a local sheriff can't call up a posse of the military, the U.S. federal military, to pursue bank robbers, to enforce local laws. But it's not at all clear to me that Posse Comitatus would prevent the U.S. federal military from enforcing federal law. I'd like to hear, again, I'm not claiming that's the case. It just seems like a reasonable argument to me. I'd like to hear a discussion of that from someone with genuine expertise on Posse Comitatus, or maybe I'll have to do some of that research myself.
Your Honor, that we think is dispositive on this issue is that if you look back to the history of the Insurrection Act and the Posse Comitatus Act, from literally the year that the Posse Comitatus Act was passed, the Defense Department puts out a guide, essentially, to all of the statutes that it considers to fall within to qualify as exceptions under the Act. Maintain that list, over the 150 years or so since the PCA was enacted. it's always included what is now known as the Insurrection Act. It has never included what is now Section 12406. And so that's relevant to statutory interpretation because even if from a modern contextualist standpoint, we wouldn't see as a matter of first principles the Insurrection Act being the type of express exception that the Posse Comitatus Act demands. There's that long-standing history of executive branch interpretation, and Congress has operated against the backdrop of that and repeatedly recodified both the PCA and the Insurrection Act. So we think that that historical understanding of treating it as an exception to the PCA has essentially been ratified or acquiesced in by Congress. You don't have anything like that in the case of Section 12406. I mean, it's very telling again and again.
By the way, I see this comment here. If Trump invokes the Insurrection Act, he fulfills the progressive fascist prophecy. That shouldn't really matter. I don't think anybody cares what the progressives say at this point. They're just lying all the time. But I think these judges are aware that if they were to tell Trump that he can't use 12406 to protect federal personnel and property, Trump would feel that he had no alternative but to go to the Insurrection Act. I think that'll play a role in how these judges arrive at their decision on the 12406 arguments.
And again, when the Defense Department puts out the list of statutes it considers to be an exception to the PCA, the modern equivalent of the historical equivalent of Section 12406 is never there, including there's a version of this list that was published just, I believe, weeks or just a few months after the enactment of Section 12406 in January 1903. Surely, if executive branch officials and Congress had intended it to operate as an exception to the PCA, we would have seen it on that list right after the 1903 Militia Act was passed.
Okay, thank you.
Any further questions?
No, thank you, Judge Miller.
Thank you, Your Honors.
All right, rebuttal.
Thank you. Rebuttal?
Rebuttal. All right.
Unless the court has specific questions, I just have a few points to make on the 12406 calling up question. The first is to respond on the question of rebellion. Of course, the court does not need to reach the issue of rebellion if it agrees that the calling up was authorized here under subsection 3 of the statute on law execution. But if the court does reach that question, I would commend to the court Judge Nelson's opinion in the Oregon case from earlier this week that I think marches through in detail the historical understanding of rebellion that refutes the principal basis on which the district court here concluded that subsection 2.
So Nelson is one of the 3 judges on the Ninth Circuit Court of Appeals, but a different 3-judge panel dealing with Trump's calling out of the Oregon National Guard in Oregon. And that Court of Appeals just issued a 2-1 decision favoring Trump, staying a TRO against Trump by Judge Immelgut, the trial Judge Immelgut. And Judge Nelson was part of the 2-vote majority for Trump. And then he also wrote a lengthy concurrence. We covered it here in a show, a members-only show. A lengthy concurrence talking about things like there is no judicial review here. Rebellion doesn't mean a threat to the entirety of the government. None of that was part of the majority opinion, so it doesn't have precedential value. But it's legal analysis favorable to Trump, and Trump's lawyer here is suggesting that these 3 judges take a look at their colleagues' thoughts on these issues. I think that's a smart move.
Who could not be met because the district court said for it to be rebellion, it has to be aimed at overthrowing the government as a whole. That's inconsistent both with the ordinary understanding of the word rebellion, and it's inconsistent with key historical precedents in which presidents called up the guard in order to suppress rebellions, like the Whiskey Rebellion, which was not aimed at overthrowing the entire government. It was aimed at opposing a particular excise tax, a particular law. And there's certainly nothing in our position, in our understanding of the term rebellion, that would allow the president to conclude that there was a rebellion based on First Amendment protected activity. We're talking about violence here through force and arms opposing the laws and operations of the government. Second point I wanted to make has to do with the exhaustion requirement that Mr. Harbert spoke about. It really is quite an extraordinary suggestion that in this statute that is dealing with emergencies, the Supreme Court in Martin said sorts of emergencies that require prompt and unhesitating obedience. The idea that the president would have to come to court and explain in detail why he concluded that these forces were necessary to call up as opposed to using these other forces. That, of course, is something that is within the president's discretion to do. That's what the president did, for example, in Portland, where there was significant unrest also in June, and the president first tried to meet that with the regular forces and only ended up calling up the Guard when that became unsafe and unsustainable. But it's also within the president's discretion to do what he did in LA and to look at that situation and say, this is widespread violence where there's a serious risk of this escalating and getting out of hand rapidly, and immediately calling in the Guard based on a determination that the regular forces can't handle this situation. And then the final point I wanted to make on the question of the time period, as I mentioned at the outset, Judge Miller, when this statute was originally enacted in 1903, it authorized the president to, it shall be lawful for the president to call forth the Guard for a period not exceeding 9 months. That was Section 4 of the statute. Section 5 then said that the president may specify in his call the period for which such service is required, not exceeding 9 months. Congress has removed that language from the statute, I think quite clearly vesting that determination in the president's discretion. Of course, we think the calling up is in the president's discretion. And the final point that I would make on that is I understand that it makes courts uncomfortable, the idea that something would be completely vested in executive branch discretion with no judicial review. That was not a point that was lost on the Supreme Court in either Martin or Luther, both cases.
Great point. Great point. This is what I wanted him to push harder at the start, but maybe he was planning to circle back in his rebuttal the entire time. I'm going to rewind. This is this notion that, listen, I know it scares you judges to not have to give up your authority to do judicial review. That doesn't mean the president's an unleashed tyrant. There are still mechanisms for checking the president's authority. They are the political mechanisms.
Expressly vested in that it makes courts uncomfortable. The president's discretion. Of course, we think the calling up is in the president's discretion. And the final point that I would make on that is I understand that it makes courts uncomfortable, the idea that something would be completely vested in executive branch discretion with no judicial review. That was not a point that was lost on the Supreme Court in either Martin or Luther. Both cases expressly addressed that point. And in Martin, the court said the frequency of elections and the watchfulness of the representatives of the nation carry with them all the checks which can be useful to guard against usurpation or wanton tyranny. And then in Luther, the court said, if the president in exercising this power shall fall into error or invade the rights of the people of the state, it would be in the power of Congress to apply the proper remedy, but the courts must administer the law as they find it. We would ask the court to vacate the injunction.
Can I ask you just one? The basis for the 12406 injunction was an ultra vires theory, and you've devoted much of your.
This is good. The Trump lawyer should have. These judges were asking the California lawyer about ultra vires quite a bit. He should have circled back to that, and it's nice that this judge is prompting him to do that on the ultra vires question.
Argument 406 injunction was an ultra vires theory, and you've devoted much of your argument against the Posse Comitatus Act injunction to the idea that an ultra vires injunction is unavailable, but you haven't made a similar argument with respect to 12406.
We have invoked the ultra vires standard on the 12406 issue. Of course, we think that's not reviewable at all. But if you get past that, then it is the ultra vires standard, and that's because Congress has never enacted a statute, either specifically with respect to 12406 or generally subjecting presidential determinations to judicial review. The president is not an agency under the APA. And so the only possible cause of action is the ultra vires cause of action. Supreme Court, to my knowledge, has actually never held that cause of action can be used to bring a claim that the president exceeded his authority under a statute. Court reserved that question in Dalton, but even setting that aside, the court's recent decision in NRC makes quite clear, as the court has noted, that that is a Hail Mary pass, and garden variety errors of fact or law do not suffice under that standard. It has to be blatantly lawless action where the agency is acting contrary to a specific prohibition in the statute or entirely in excess of delegated powers. Of course, there is no specific prohibition in Section 12406. It's an authorization.
The Constitution gives Congress, the calling forth power, right? So the president's only ability to call forth is that which was delegated to the president by Congress, by statute. The president has absolutely no constitutional authority to call forth the militia except to the extent granted by Congress. Is that correct?
I agree with that,
You
Judge
agree
Sung.
with that?
But that's what makes this a claim that the president is exceeding his authority under the statute. That's the claim that they're making, that he's acting ultra vires because he's called forth the guard in circumstances that don't meet any of those enumerated subsections. And even if there were judicial review of that, it could only be this ultra vires standard where you're asking, is there a specific prohibition? No, there's not a specific prohibition that he's violated. Has he acted entirely in excess of his delegated powers? I think at a minimum, as long as there is the sort of colorable basis in fact and law.
That's confusing the merits with the existence of a cause of action.
I think the two sort of merge when we're talking about the ultra vires standard, because the court has said that cause of action is available only for those sorts of violations and not for garden variety errors of fact or law.
So counsel, Judge Miller, can I ask a few questions about the PCA? So your friend indicates that vis-a-vis the PCA issue, he believes that NRC is inapplicable. Could you I know you address NRC in your PCA filings, but could you address that argument here?
Sure. So again, we don't think there's any available cause of action for a plaintiff to challenge an alleged violation of the Posse Comitatus Act because it's a criminal statute, and the ultra vires cause of action has never been extended and used for an alleged violation of a criminal statute. And I think as the Supreme Court and NRC was quite clear, they have been looking to put limits on that cause of action and not expand it into new territory. And so applying it to an alleged violation of a criminal statute would be something new that doesn't have sort of a long-standing analog in equitable practice. But even setting that aside, if there is some cause of action here, it could only conceivably be the ultra vires cause of action. That's certainly the only one on which Judge Breyer ruled. That's the basis for the injunction that he entered. And so they would have to meet that very stringent standard in order to obtain relief. And they can't possibly meet it here for all of the reasons that we outlined in our motion for a stay.
All right, my second question on the PCA is your friend has indicated that the exception, or
By friend, he means the California lawyer, the opposing counsel.
that the ability of the president to call forth when he is unable to, with the regular forces, execute the laws, that doesn't count under the PCA as a circumstance expressly authorized by an act of Congress for a variety of reasons that he outlined in argument and in the briefs. And I know you again addressed this in your pleadings, but could you address it here? Why, if we got to consider this in the ultra vires context, whether your position on whether that does constitute the type of exception described in 1385 as something expressly authorized by an act of Congress?
Absolutely. It qualifies as something expressly authorized by an act of Congress, and I frankly have a hard time understanding how it could not be. The Section 12406 expressly authorizes the National Guard, when it has been federalized, to execute the laws that the president determined that the regular forces were unable to execute. So there's an express authorization to execute the laws. I fail to see how that could fall outside the language of the Posse Comitatus Act that says, except in cases and under circumstances expressly authorized by an act of Congress.
Well, one of the arguments your friend makes in his PCA pleadings, which you may have addressed, but I didn't see it, is they cite 10 U.S.C. 12405 and talk about how even members of the Guard called into service are subject to all laws and regulations, et cetera, which would include the PCA. So what's your response to that? And again, I didn't see it in your pleading, but I might have missed it.
I mean, I guess that strikes me as a bit of a chicken and egg problem, but I don't think that language would override the express authorization in section 12406 to execute the laws. I mean, subsection 3 of section 12406 would effectively be nullified if you said the National Guard couldn't execute the laws that the regular forces were unable to execute, and therefore the president called up the Guard to execute them if they couldn't do that without violating the Posse Comitatus Act.
Judge Miller, thank you for letting me ask those questions.
All right. Thank you very
Thank you,
much. We thank both counsel for their helpful arguments. The case is submitted, and we are adjourned.
And that, my friends, is that.